successfully resolved at the Immigration Appeal Division, and it highlights an important legal concept that many sponsors do not fully understand. This case involved a parent sponsorship application under the Parents and Grandparents Program. As many of you know, Canadian citizens and permanent residents can sponsor their parents for permanent residence, but the law imposes strict requirements on sponsors. One of those requirements appear in Section 130 of the Immigration and Refugee Protection Regulations. The provision states that a sponsor must reside in Canada. On its face, this sounds simple, but in practice, the meaning of reside can be legally complex. In this case, the sponsor was a Canadian citizen who had been living and working in Thailand for approximately a year and a half when immigration made the decision on the sponsorship. Based primarily on the fact that the sponsor was physically outside Canada, the application was refused and the parents were not granted permanent residence. The refusal was deeply concerning because physical absence from Canada does not automatically mean a person has ceased residing in Canada. Residence in Canadian law is not always defined to are physically located on a given day. Instead, courts have developed a broader and more nuanced concept. We appealed the refusal at the Immigration Appeal Division and built our argument around the legal principle sometimes described as the centralized mode of living. This concept has been discussed in multiple Canadian decisions and focused on where a person's life is fundamentally anchored, where their home, family ties, financial interest, and long-term intentions are centered. In other words, residence is not simply geography. It is a holistic assessment of where a person's life is truly based. In preparing this appeal, we presented evidence showing that despite the sponsor's temporary employment abroad, their centralized life remained in Canada. Their ties, intentions, and overall pattern of living demonstrated that Canada continued to be their place of residence. The matter proceeded to the Immigration Appeal Division, and I am very pleased to share that we were able to achieve a successful outcome at an earlier stage of this process. The appeal was resolved before a full hearing, allowing the family to move forward without the stress, delay, and cost of prolonged litigation. This was not an easy case. Residency questions are often fact-intensive and legally challenging, particularly where a person spends extended time outside Canada.